Who is next?
May it please the courts, my name is Kindiki. For the 19th, 20th, and 21st respondent. My lords and my ladies, on the 13th of May, 2021, a 5-judge bench of the High Court made a decision which, in our humble view, is one of the most extensively reasoned and groundbreaking decision in the entire history of our country's constitutional jurisprudence. It is that decision that the appellants now ask this Honorable Court to overturn, citing an array of grounds. My lords, my ladies, we humbly submit that the consolidated appeals be dismissed in their entirety with costs to the respondents, and the decision of the Superior Court be upheld and affirmed for the grounds that we submit herein below. My lords, my ladies, all the appellants view that the so-called Building Bridges initiative was a popular initiative. With tremendous respect, we strongly disagree. Instead, we agree with the Superior Court that this was not a popular initiative. It was rather it was a presidential initiative or executive initiative, which is not provided for in our Constitution, and the attempt subsequently by the initiative's promoters to rope in the people at the tail end of the process to sanitize their illegal and unconstitutional venture must spectacularly fall on the facts and the evidence of Kenya in its official rather than private capacity. We say so for these reasons. One, the fingerprints and footprints of the President of the Republic are strewn and splattered all over this heinous affront on the Constitution of our country. My lords, my ladies, secondly, the President created a task force, after which he created a steering committee to implement the recommendations of that task force. And the mandate of that steering committee was clearly stated in paragraph B to include making or proposing legal, administrative, and even constitutional changes. Thirdly, on that point, is that the President established both the task force and the steering committee via the Kenya Gazette. It is our submission, my lords, my ladies, that the Kenya Gazette is not a newsletter, it's not a newspaper, it is not a pamphlet, nor is it a private publication. It is the official publication of the government of the Republic of Kenya, and for that reason, the president, in appointing these institutions, was acting in official capacity, which is our first argument. Further, to cement that argument, the steering committee so established generated a report, and attached to that report was a bill to amend the Constitution, which bill is the subject matter of this litigation. And it is the bill upon which the signatures, which are in contention here, were collected. The fingerprints of the president and his footprints are also evidenced by this, that the submission of the task force report to the president, the submission of the steering committee report to the president, the launch of the collection of signatures exercise, and all other events associated with this ill-fated exercise or process were presided over by the President of the Republic of Kenya using state machinery, and none of these meetings or events took place in anybody's private home. My lords and my ladies, it is our further submission that the reports of the task force on the same point and the report of the steering committee were addressed officially, and I quote, to, open quote, His Excellency, the President of the Republic of Kenya and Commander-in-Chief of the Defense Forces, the Honorable Uhuru Kenyatta, comma, CGH, end of quote. Further, it is not controverted that the collection of signatures for this cause was aided to some extent by public officials, chiefs, and other public officials within the executive arm of the executive, which the president presides over. At no point in the whole exercise did the president relinquish his tools of official functions, as was ably cited by my learned friend, Mr. Mutuma, the ASA presidency in 2014, during the international criminal court cases. And I am privileged to have been one of the defense counsel in the Kenyan cases at the International Criminal Court. And when it came to the hearing of that court and the initial appearance, the president of the country downed the tools of power openly and publicly and signed a deed, in which deed he appointed his deputy for approximately 60 hours or thereabout to act as president of the country so that he could attend to what he termed a private and personal matter as a private citizen, Mr. Uhuru Muigai Kenyatta. My lords and my ladies, on the second argument of that point, we submit the President of the Republic of Kenya has no right to initiate a popular initiative. Why? Because this avenue of popular initiative is reserved for private citizens, including civil society, and is not available to state officers or state organs. The learned judges in the Superior Court took time to explain that the historical context of Article 257 on popular initiative, according to the Bomas report, was the history, the checkered history of Kenya with constitutional amendments. And therefore, it was clear that citizens wanted an avenue where they can amend the constitution and force government to legislate things that they think government through the organs of state does not wish or is not ready to legislate. How then can the same government, which is supposed to be compelled to legislate by the people through a popular initiative, be the same government using that avenue? And therefore, we agree with the learned judges of the Superior Court that there were other avenues available to the head of state and the president to initiate whatever amendments he wanted to do. First, under Article 132 of the Constitution, the Cabinet may make proposals to, for legislative proposals. The Cabinet can do that. Also, the Attorney General under Article 156 of the Constitution normally aids the President in bringing government legislation. And under this Constitution, particularly, the office of the Leader of Majority in the National Assembly and the Leader of Majority in the Senate is actually the avenue through which government bills and legislation proposals are channeled. And I speak that with some little authority by virtue of my previous background outside the premises of what we are dealing with today. That therefore this was the wrong avenue for the President to use, and he had other avenues to use. Secondly, on the same point, the second reason why we say that this route is not available to the President of the Republic of Kenya is because, as it was found in the Superior Court, that there was no evidence tabled to provide that the President had used other avenues available to him and failed. On the second thematic area of public participation, which my learned colleague Geronimo has submitted, I just want to add the following comments. First, I was somewhat surprised when learned senior counsel Otiende Amolo yesterday, or is it the day before, submitted before this court, tried to demonstrate how it is it's impossible for all the steps of public participation identified by the learned judges in the Superior Court for public participation if we are to allow Wanjiku to be the one to drive the popular initiative. We disagree with that view because, and I heard senior counsel Otiende Amolo exemplify and ask the court to reflect on whether, for example, Wanjiku can have the bill published, I don't know, in the national languages, the national language, which is Kiswahili, the official languages, which is English and Kiswahili, the vernacular or indigenous languages, and so forth and so on. And he said if we submit Wanjiku to this kind of procedures, it will not have been possible, and I hope I'm not misquoting learned senior counsel. Our view is that this demand, this 10-step process demand, was not the invention of the learned judges in the Superior Court. It is a dictate, a requirement of the Constitution in Article 7 of the Constitution, which the learned judges relied on, which calls on state organs and state processes to, for example, use the languages and even try to promote indigenous languages and the use even of Kenya Sign Language and Braille where possible. And when it comes to the technical side around Braille and Kenya Sign Language, the Constitution is considerate and uses such terms as promote as opposed to demanding outrightly that that must be done. And therefore, on this public participation, it is a demand of the Constitution. Secondly, on the same theme, it is our submission that both the popular initiative and the parliamentary initiative must therefore adhere to what the learned judges provided for the 10 steps of public participation. There was very little public participation in the processes that were taken up to this point before this litigation arose. For example, the example was given of Siaya, which passed the bill upon receipt. Siaya, in their wisdom, the assembly in Siaya County, in their wisdom, decided to pass this bill within 24 hours. I don't know whether they did the public participation at midnight or at 3 a.m. and what methods they applied. Within a day or two, they had passed it. Tana River attempted to do the same, but the county assembly of Tana River was stopped on their tracks, and their action, which had already taken place, was nullified. Abe Brere, I hope I'm not mispronouncing, Abe Brere versus the Speaker of the County Assembly of Tana River and 2 others. And the judge said, don't even take what you have passed to Senate or even National Assembly. And the thing died. But because the promoters had already had their kill, they had enough majority, so they proceeded, notwithstanding that they didn't have Tana River County Assembly on board. And my Lord, why are we emphasizing this? It's because there is a reason why the Constitution demands that the bill be submitted in Article 257, the bill be submitted to the county assemblies for 90 days. The county assemblies have 90 days to process the bill. There's a reason, and that reason is public participation, among others. I say so because I had also the submissions yesterday by learned counsel, Mr. Gumbo, who told this court that in a different issue of signature verification, the regulations demanded that IBC should take 14 days, but in the wisdom of IBC, they decided to shorten that process to 5 days, which included a Sunday, which is normally not computed in terms of time. And therefore making the whole issue of statutory timelines a laughing stock. I am afraid to submit that, unfortunately, for such an important institution of the state like IBC to be dragged into this business of hop, step, and jump, similar to the legend in the Simon Makonde story, where in 7 days, the politicians involved in this process actually marshaled and stampeded millions of signatures in 7 days, like Simon Makonde, who was born on Monday, and something happened on Tuesday. I think he wasn't named. He got married on Wednesday. On Thursday, he fell ill in water.
I'm not sure it was the same week, but carry on.
Thank you, my Lord. My Lords, therefore, we submit that public participation must start earlier and continue throughout the process, and it must involve the people. We also submit that the appellant's erroneous view that those who signed to support this bill, the 1 million that signed, are presumed to have understood the content of the bill, which is the gravamen of the appeal, part of the gravamen of the appeal by the Honorable Attorney General. This submission cannot stand because, my lords and my ladies, that public participation cannot be presumed. The authorities that we have filed, the Robert Gakuro versus County Government of Kiambu, the Doctors of Life case, and so many other cases, even outside this country, we filed them in our documents. These authorities say that public participation is both qualitative and quantitative. It cannot even be presumed, it has to be real. I think in Doctors of Life, the judges said it has to be real, not illusionary or thereabouts. Therefore, when you see county assemblies almost all of them, the entire country, passing such a monumental, or rather passing or endorsing such a monumental bill, which is amending not less than 74 parts of our Constitution in a swap, making the regime of...
Counsel, sorry. Was that part of the evidence before the Superior Court? The statement you make, is that...
Which one in particular?
That the county assemblies passed it in speed light. Was it a matter of evidence before the Superior Court?
You know, my Lord, I don't want to lie to the court. I came on board this matter at this level, and therefore I don't want to take responsibility for that, and I'm relying on our written submissions. So maybe that's something that Mr. Mutuma can clarify.
Okay.
Thank you. Ms.
Counsel, Prof, just a point was raised about who bears the burden. And if I heard the appellant correctly, they seem to say that consistent with the requirements of the Evidence Act, he that alleges must prove, and they said that insofar as your clients were alleging that there was no public participation, it fell upon you to prove that. What's your comment on that?
I absolutely agree. That is the position of the law. But in context of this matter, once, first of all, there is the standard of proof, which in this kind of a matter, which are not entirely civil matters, they are sui generis proceedings, but they are not criminal matters. So the standard is normally of a lesser, so on a balance of probability. And I think at the Superior Court level, the issue of public participation, lack of it, was proved to that level, and that's why the judges took a bit of time to agree largely with the appellants, with the petitioners' positions and evidence. I am referred by Mr. Mutuma to page 1663 of our volume 4 of the Record of Appeal. Volume 4 of the Record of Appeal, page 1663, where the issue asked by my Lord, Mr. Justice Tuyot, is answered in the affirmative, particularly the affidavit of Miruru Waweru, paragraph 8, how the county assemblies passed this bill, considered this bill in a lot of haste. Because of my time, my lords and my ladies, we also note that the MCAs, which is a fact, were given a car grant, but that's neither here nor there. That does not mean that they didn't have to follow the Constitution and the timelines given by the Constitution. Our submission is that the timelines given by the Constitution or statute are deliberate. They cannot be played about with or hurry them up, especially when they concern such serious and grave amendments.
The period was reduced from 90 days to how many?
Within 30 days, I think the entire country, except one or two, like in Meru took a little more time, maybe about 40, 45 days, I'm not sure. But the rest of the county assemblies considered this bill in less than 30 days, within 30 days. And that is in our affidavit.
In your view, what was supposed to happen after it's committed to the county assemblies within that 90 days?
Qualitative and quantitative public participation.
Through the county?
In the county, by the county assembly, which of course includes, if you look at it from quantitative and qualitative approaches, that includes time. And for me, they should have taken most of the 90 days to comply with the 90-day deadline, maybe 60 days, 70, 75, 80, or even 90 days. My lords, my ladies, allow me to rush to something which was submitted here by Counsel, Senior Counsel Atiende Amolo, on the JLAC report of Parliament because he made some remarks that it's not binding. I just want to say that this report is a public document. We also have produced it as a result of the directives of this court to adduce additional evidence. We want to simply submit that this report of the Joint Committee of the National Assembly and Senate, the Committee on Legal Justice and Legal Affairs, this report was tabled in the two houses of Parliament, and once tabled, it became the property of the two houses. And it is not true to argue that once it was tabled, because it was not voted on, then it has no evidentiary value. We believe and we submit that both that report and the proceedings, the answered proceedings of the Senate, which reflect the true records, are important evidence, which demonstrates one thing, my lords and my ladies. What the two sets of documents demonstrate is that within the proceedings in Parliament, including the Justice and Legal Committees of both houses, it was clear from the report and from the Hansard proceedings that the finding of the report was that many provisions in the bill, the proposed amendment bill, were unconstitutional. But surprisingly went ahead and said, but we recommend it be enacted. For example, the issue of Schedule 2 to the report, the JLAC report, which consisted the list of, the issue of additional constituencies. The committee found that there were legal issues that made that schedule inconsistent with the law, and recommended actually, there was a recommendation even of severing that Schedule 2 from the report. But we want to leave it at that and say that it is not true that these proceedings and these reports are of no probative value. We submit, my lord and my ladies, that I also listened with significant surprise also as learned counsel, my senior Mohamed Nyaoga, told this court something about the immunity of the head of state. And I thought I should just, in a snippet, submit that, the old idea of absolute immunity of heads of state has been abandoned in all the constitutions of the world and under international law. It's an archaic legal doctrine, originally from international law, but which got infused in national constitutions. But since, especially 1990, the landmark international case of which this is not in our submission, but just to help the court, the Pinochet case. The Augusto Pinochet was a former head of state in Chile, and he did what he did for many years and fled and went to Europe. He was arrested, extradited, returned back to Chile, and in that case, because that case took place in the UK, the judges made it very clear, the House of Lords, that it is not the job description of a president to torture and kill people. So immunity cannot be absolute, because those were their charges against Pinochet. And from there, that doctrine is old, and the court should not give any effect to an argument that immunity of the president is immune. The Constitution in itself, the court really guided on that area, is very clear. Does not include commission of international crimes, does not include when the person leaves office, it does not include actions which are not functional. They are not related to the function of the head of state. My lords, my ladies, allow me to say a few things. I know I have 12 minutes on the basic structure. And I'm sorry, my Lord Justice Kiage, I have to do this because the same thing can be attacked from a million sides, and I won't repeat, I hope I won't repeat anything about basic structure. And for me, what arises from all this discussion about basic structure, eternity clauses, and so forth and so on, is whether, my lords and my ladies, there is a hierarchy of norms in our Constitution. That is the question. is there a hierarchy of norms? We submit that there is a hierarchy of norms. Why? We can even start with Article 255 itself. 255 is saying, my lords and my ladies, 255(1) is saying you can amend the Constitution through Parliament under 256 or through the people under 256. But there are 10 or so things you cannot, whichever method you're using, you must go back to the people. Paragraph A to J of Article 255(1). That's already a hierarchy. It means you can touch the rest, but you can't touch this one. Second example, in the interest of time. Learned Senior Counsel Professor Githu Muigai, who I consider to be my complete hero on this topic of constitutional amendments by virtue of his PhD thesis, submitted before this court yesterday that the Independence Constitution had some entrenched, some superior values, but they were removed. But they were returned again at Bomas, and they found their way in the 2010 Constitution. So what council, the Appellant's Council have been telling us is that, oh, the court never said what are these entrenched provisions or basic structure or eternity clauses. And without going into the tautology and phraseology, there is, in my humble view, there is a hierarchy of norms. I'll give you an example, my lords, and some of these questions were even raised from the court, to my great pleasure and satisfaction. If you want to change the Constitution of Kenya and remove the provision that says that Kenya is a democracy, I think it's in Article 4.2 or thereabout, Kenya is a democratic state, multi-party democracy. You want to replace that and say, for argument's sake, that Kenya is a constitutional monarchy. Is that really the same as if you want to change the Constitution, Article paragraph 249 on independent commissions, which says that the number of commissioners is between 3 and 11 and 9. Suppose you want to say you lift from 3 to 5 and lift the other side, the ceiling side, from 9 to 11. Will amending that amendment be the same as an amendment that is trying to convert Kenya from a democracy, a multi-party democracy, to a constitutional monarchy? Are they the same? They are not, in our humble view. Second example. If you want to change the territory of Kenya in Article 5 of the Constitution, the territory of Kenya is defined. What the territory of Kenya, what constitutes the territory of Kenya? It is that territory in place on effective date of the Constitution and then split into then the counties. So the territory of Kenya is defined in terms of the whole and the subnational units, the counties. You want to change that and sever some part of Kenya and donate as it used to happen in the old days of international law. If a sovereign was happy with a sovereign of another country, they could donate a part of their land or their space to a neighboring friendly country. That is how Alaska came to be part of United States of America. If you look at the geography of North America, Alaska is somewhere between Canada and United States. Somewhere in between there. Sorry, the other way around. Alaska is beyond Canada. It's after Canada. So you have United States of America, you have Canada, and then you have Alaska. Why? Because it was it was a gift, it was sold to the American president, leader, by the leader of USSR. It was part of USSR across the ocean. So it was sold for $3 million. some 300 or 200 years ago, and so forth and so on. Therefore, we submit with great respect that there is a hierarchy of norms. All norms are not equal. But we secondly submit that the judges of the Superior Court did not say you cannot touch these superior entrenched basic foundational provisions. They didn't say so. Instead, they said you can change, but not this way, not in the ordinary way. You must go back to the people and the people themselves. That brings me to my last submission, because I have 5 minutes, which I will spend now, on my last submission on this area, which was introduced, again to my great satisfaction and interest, because of my scholarly background, by learned senior counsel James Orengo, on the place of the supremacy of the people, because it's relevant to this. We submit as follows, and I agree with senior counsel James Orengo on this. Elsewhere we've argued this issue, and we are concurrent about the supremacy and the elevated status of an organ which is not really considered as a constitutional organ. But if you look at it carefully, there is an organ, a constitutional organ called the people. But what I disagree with tremendous respect to my learned senior counsel Orengo is characterization that this organ, in quote, called the people, must exercise their sovereignty within the Constitution. For the following reason, my lords and my ladies, if you look at the preamble of the Constitution, the people are the creator of the Constitution. So the Constitution cannot be superior to the creator. It's a creature of the people. Look at the preamble. I know there is a provision in one of the foundational principles, one of the basic structure principles, I think there's 2 or 3 there, which says, Article 2 or 3 of the Constitution talks about that the supremacy of the Constitution. It's Article 2. It's Article 2. Yeah? Supremacy of the Constitution, how this Constitution is supreme. But that supremacy ends where the power of the people starts. And that's why the Constitution in the preamble is saying, we the people. Let me just read that. I have 3 minutes. Very important.
Professor, as you do that,
yes,
I understood Senior Counsel Orengo to say that whereas indeed the people are sovereign, the Constitution in express terms says that they shall exercise their sovereignty only in accordance with the Constitution. Those are plain words, black and white.
Which I disagree with, my lord, with great respect.
No, sorry. Are you disagreeing with the words that's how they are written, or you're agreeing with the statement?
I am disagreeing with the notion that the people are bound by their creature. The creator is bound by the product of their creation to do certain things in a certain way.
But can we first of all agree, does the Constitution say that they can only exercise their sovereignty in accordance with the Constitution? So we agree, first of all, we move from text to whether now we agree with the text.
I agree, my lord.
All right, carry on.
Thank you. The reason I argue this is because, unlike my learned senior, James Orengo, who argued that the Constitution is supreme and even the people therefore must act within it, for the reason I have given, that the people are the creator and the Constitution is the creature, the people can even decide to abolish the entire structure here themselves. The people can decide that. And therefore my argument is, yes, the Constitution is supreme, especially the elevated clauses. The Constitution is supreme. But above the Constitution is the people. And I dare submit, above the people is only Almighty God and the blue sky. if you look at the preamble to the Constitution, it says, and I quote as I end my submission, "We, the people of Kenya," the opening words. That should even send a, if you're interpreting the Constitution, that should tell you the first sentence, the first phrase in this Constitution, "We the people," the Creator. We the people of Kenya, acknowledging the supremacy of the Almighty God. The only supremacy above the people is that of God Almighty. It's in our Constitution. I am not bringing theology here. It's in the Constitution made by the people of Kenya. Therefore, without wasting time, my Lord, I believe that above the Constitution is the people. And above the people is only the Almighty God and perhaps the blue sky, because it's also hovering over us as the people. For those reasons, therefore, my lords and my ladies, with tremendous respect, I urge this court to dismiss all the consolidated appeals, the appeals as consolidated in their entirety with cost to the respondents. I also urge this court to find that apparently what we are talking about here was a botched attempt to overthrow the people and their constitution at the same time. Luckily, by the grace of the Almighty, the judiciary, through the Superior Court, came and, in my view, rightfully interpreted this Constitution and declared that botched attempt to overthrow the people and their Constitution a nullity. Unless there are questions from the bench, I will request, my Lord and my ladies, that I be permitted by the court to resume my seat.
I guess there is none. Thank you very much, Professor Kindiki. Can we have the next respondent?
May it please your lordships and ladyship, my name is Gilbert Nyamweya, instructed by Mr. Murara Omoke to lead his team. Your lordship,
Just say for which the respondent?
for the 76th respondent. Your ladyship and lordships, we come on our knees pleading that if you could enlarge